So we're going to do today the next in a series of trade talks. We're going to again talk about the 301 tariffs that have been imposed by the U.S. on China, goods out of China. And I just want to very quickly at the end talk about what's going on with the 232 tariffs. So let's start with what's new with the 301 tariffs, because we've talked about them before. On July 6th, the U.S. Trade Representative published the information about how companies go about obtaining exclusions from the 25% tariff. The interesting point to keep in mind, first of all, of course, is that these tariffs are based upon the country of origin, not the country of export. We've already started to get questions from clients who say, well, my equipment is in China, but its origin US or its origin Europe, and I don't want to have to pay the tariffs. Well, you shouldn't have to, provided you have the documentation to back up the origin of the equipment. The timeline is a bit unclear in the sense that we know for sure that by October 9, 2018, anyone who wants an exclusion will have to have filed for it. The lack of clarity comes after that, in the sense that the filing has to be done, it has to be vetted for being complete, and then it gets posted on regulations.gov. At that point, anyone that is posted, anyone who objects, has 14 days. And once there is an objection filed, then the original petitioner has another 7 days to file any reply. Of course, all of this is done through regulations.gov, and the docket number for this is USTR 2018-0025. One of the interesting changes between the original 232 process and the now 301 process is that in the 232 process, only companies could file, and the exclusion applied only to the product that the company filed about. In this case, trade associations can file, and the exclusion, if granted, will cover all of the product regardless of who the importer is. Also, the exclusion will be for 1 year, and it will be retroactive to July 6. So unlike the 232 process, where the sooner you filed, the better off you were, in this case it will make no difference as long as you get your request in on time. As of about an hour ago, the official Federal Register notice had not been posted on regulations.gov. And so there is, at this stage, nothing official in terms of the forms to be used for the request, any objections or any reply, but I'm sure that's going to come. So let's spend a few minutes really talking about, if you're stuck in the middle of this 301 morass, what are some of your options? And the starting point for all of this is to make sure that your products are correctly classified. If you've looked at it recently, that's one thing. If you hadn't looked at it in a while, be wise to start there. The next question to ask, assuming that you've come to the conclusion that your goods do fall under a tariff number that's covered by the 301 case, can you engage in tariff engineering? Now, that's a perfectly legitimate process in which what you do is redesign your product so that it legitimately, and the emphasis is on the word legitimately, qualifies somewhere else in the tariff. If you've looked at that and that's not an opportunity or an option, sometimes because of cost, sometimes because of technology, sometimes because of other reasons, then look at alternate sourcing. Is there another country where you could get the goods? If so, how long would it take that supplier, whether it's a US or a foreign manufacturer, to ramp up and be able to provide the information for the goods for you? You want all of this anyway if you're going to consider filing an exemption, because of course, exclusion. Because of course you have to have that kind of information available for the exclusion request. And if you're going to file, are you able to distinguish your product sufficiently from that of your competitors, or are they going to, so to speak, get the benefit of your efforts? The other thing to keep in mind when you're thinking about filing an exclusion is to make sure that you anticipate what the objections may be. They should be something from a supplier that says something other than, well, we came down to a disagreement over price. But make sure that you've thought about that. Keep in mind also the list 2, which is the new list of products that has been proposed. This is the one on which 10% of goods 10% duty would be imposed on goods from China. That's still going through the process. It's going to be the end of July before the last of the post-hearing rebuttal items is due, so it's going to be probably early August before we know what the status is on that. Make sure as you're doing all of this that you work closely with your trade compliance consultants. We recognize that a lot of the small and medium-sized companies are really looking carefully at how they stay in business and remain compliant. That is a challenge, but also keep in mind that Customs is looking very carefully at trade flows, trade patterns, and trade volumes, and if they begin to see sharp differences, that's going to cause more enforcement. And of course, Customs stays at the ready for transshipments. There will likely be a list 3. That is the list that is going to be published, assuming that the Trump administration goes forward. That would be the additional $200 billion worth of goods out of China, on which additional tariffs would be imposed. And I want to close finally, as I said I would, with just a couple of quick comments on the 232 tariff. At this stage, the only quote-unquote deals that have been made are with Argentina, Australia, Brazil, and South Korea. For all of them, on June 1st, the absolute quota for steel and the absolute quota for aluminum apply, and of course you have to check each country to see which product line is involved. And then on July 1, just a few days ago, the quarterly threshold for the tariffs kicked in, and it ends on September 30, 2018. This is a very complicated topic. I've gone over some high points very quickly. For more information, feel free to check our website and our blog, because we have lots of client information that we've published on this topic. Thank you.